Hello, everyone, and thanks for joining today's show. My name is Mike Vanelli, Vice President of Marketing at Assure, and today we're going to talk about non-competes. Like going 20, 25 years ago when I started my career, it seemed like non-competes were a very common thing. And it seems that over the last, especially the last maybe decade, I think we see fewer and fewer of them. And I think the biggest reason is there's this perception that non-competes aren't enforceable. And we do see a trend in the courts where there are components, at least, of non-competes that are maybe not enforceable, but difficult to enforce. And so we would encourage employers to not throw the baby out with the bathwater here. There are still good reasons to have non-competes, if not non-competes, at least non-solicitations and non-disclosures and other legal protections you can give yourself as a business that are enforceable and also align with the culture that you're trying to create with your employment brand. And so to help me unpack this topic today, Brian Shenker, a regular guest of the show. Brian has extensive experience defending class action and collective action lawsuits under federal and state wage and hour laws. He successfully defended wage and hour audits conducted by the U.S. and New York State Departments of Labor. Brian regularly handles cases before courts and administrative agencies involving claims of discrimination, sexual harassment, and retaliation. So welcome back to the show, Brian. Looking forward to today's conversation.
Thanks for having me. An interesting topic, as we always find good ones here.
Yeah. So let's just start out real simple. So I think most people generally understand what a non-compete is, but give us a working definition in the starting place for today's conversation.
Sure. So I think non-competes are probably the most well-known of the contractual mechanisms for protecting a company from, either unfair competition or other companies coming in and poaching employees, or simply just your employees going to a competitor. We kind of look at restrictive covenants as a tiered structure. And so this is what I'd call the highest tier. Non-competes really give the company the most protection against unfair competition. So what do these do? They prohibit an employee from, after their employment ends with a company, from working with a competitor for some reasonable period of time within some reasonable geographic territory. So like you said, non-competes are still enforceable in most jurisdictions. There has been increased scrutiny of non-competes, whether at the state, local, or even federal levels. But as we'll discuss today, when drafting a non-compete agreement, there's certainly things that can be done that will make the agreement much more likely to be enforced. And so again, I think these are absolutely important, to be used for the appropriate employees, to protect a company's, trade secrets, the company's goodwill, and other confidential information. Companies work hard and invest in their resources and their employees and their money in other areas to create things that work to their advantage. And if a company does not put in these protections, like you mentioned, non-disclosures, non-solicitations, and even non-competes, they're potentially allowing their hard-worked resources to just walk out the door with an employee and to have little to no recourse against that. So, in terms of non-competes, I don't think those should necessarily be the default, the standard provision you're putting in every agreement, but it's something to seriously consider. And we'll get into this today, which types of employees they should be considered for. Certainly in terms of the state legislation we've seen throughout the country, one of the big issues states and courts have is enforcing non-competes against low wage earners. But again, there might be certain circumstances where that would be appropriate. But this is what we're really talking about: protecting your company's hard-earned resources, trade secrets, and not allowing unfair competition to destroy what the company's created.
Hey, Brian, speaking of things the company has created, so to me, one of the things I think I wrestle with as I think about advocating for employers, certainly as an attorney, you have a legal perspective. What is enforceable, what is not? How do you protect the interests of your business clients, right? Their trade secrets, their clients, etc. But there's also an employment brand component here, right? I've heard small business and owners talked to me before about the kind of culture they're trying to build, and they almost view non-compete agreements as a prenup in a marriage, right? And it just, and I mean that in a negative sense. So forgive me if you're pro prenup, but they want to create this culture of family and inclusivity, and we're all in this together. And why start out from almost this adversarial relationship by codifying these things in our contract that if you leave me, this is the price you're going to pay. I don't think it has to mean that at all, but I'm just kind of sharing feedback that I've heard from business owners. Can you speak into that about how you see balancing protecting your rights and putting the legal framework in place to do so, while at the same time managing your employer brand?
Sure. And first, I think that's a great analogy that you made. And look, the point that I make to employers is that your employees are only loyal to you and part of that family as long as they're with your company. Oftentimes when I'm dealing with a litigation, and whether it's any type, trade secret or unfair competition claim, discrimination, or wage and hour, one of the first things that my clients will tell me is, oh, we treated this individual like family. They were part of everything. They came to family events, and I think that's great. I think it's excellent to build and foster a culture that's very inclusive. But at the same time, you need to understand, business owners need to understand that their employees are there to support the business, and that they really are only loyal as long as they're getting a paycheck from your company. And so it's not about, non-competes are not about what's going on during that time they're working for you. It's making sure that, when the time comes that, and they leave, that, you'll have the protections in place. Since without that, they'll be, like many clients, coming to me and saying, how did this happen? We had such a great relationship. And I don't necessarily see that, having non-compete agreements, creates any negative element in a company's culture. I think that, many employees, especially for instance in sales or other, let's say technology, software, those types of areas, there are many different areas where employees may be expecting these, right? They may have had non-competes or other restrictions at prior employers. So, this might not be as big a shock to them as an employer might think. And I think it also touches on the other point, like that, you only want to use non-competes for appropriate employees, right? These are generally going to be, higher level individuals, or, individuals who have access to, very important information or very important client relationships. And so, look, your own business is very important to you, and I would say, the continuation of the business is more important than any particular employee. And so having these, protections in place is really the certain way to ensure, the continuity of the business when a key person or someone with key information leaves.
Yeah, I'm glad I asked the question, and we didn't talk about this before today's meeting. I really feel the same way. So I've heard that concern from folks, but the employment relationship the term family may be overused a bit. You don't get to choose your family. You do get to choose your work relationship, and that goes both directions, right? The employees get to choose who they work for, especially in a a sub 3.5% unemployment rate world. With the labor shortage, employees really have more power now than they ever have when it comes to choice. And employers obviously have choice to whom they hire. I think maybe the guidance that I would give to employers here is, if you're gonna, and I think there's plenty of good reasons to do, Brian will unpack this for us, but if you're gonna do and use non-compete agreements, how you deliver that agreement to me means everything when it comes to employment brand. If this is simply part of the new hire packet that gets mailed and it's a bunch of forms for the person to fill out, then just the way you're interacting with that employee, you're messaging to them that this is all transactional legalese stuff, right? But if you actually sat and explained why, here's why we have this non-compete, and here's why it applies to your job family, because we've built X number of years or decades and millions of dollars building this proprietary yada, yada, yada. If you explain the why, people generally not only understand, they appreciate, right? And then feel drawn into the story. In signing the document probably doesn't hurt your employment brand. It probably strengthens it, because you've really communicated the value of these things that you hold dear, and that you're asking them to hold dear as well. Anything else you'd want to say on non-competes in general before we kind of talk about some of the considerations that employers should make?
Yeah, sure. Well, and I think you just made a great point. I think, one of the ways you explain these to employees is, look, whether it's someone who's going to be given a lot of confidential information, saying, look, we're entrusting you with, everything we have, our most important secrets, and we need to have some protections, and we hope you're going to do great things. We don't want this ever to come to this, but because of the level of information you'll have, or for instance, we're going to get you involved with one of our top customers. You're going to be the face of our organization with these customers. And we'd love for you to grow those businesses, but look, we also need protections so that if one day you leave, you're not going to take that customer with us. And so I think those types of things can be explained. And look, there's also the other side of it, which you can explain. Look, we want to protect from other companies trying to poach our employees. That often happens as well, where it's not necessarily the employee being the bad actor, but it's and I've dealt with this before, when there's an established business in an area, and a company wants to expand to that area, and they'll poach one by one. They'll take some. They'll first try to get some of the top executives. Then they'll try to they'll go top to bottom and try to get everyone to come along. And so that can be devastating to a business. As I've seen, in one situation. It entirely destroyed that geographic part of the company's business. They couldn't do business there anymore after this other company came in and poached essentially all their employees. And they had some restrictions in place, but not ones that were necessarily enough, especially for the top employees. So I think, like you said, we'll go through some of these issues, some of the elements of non-competes that can really prevent some of those devastating impacts.
Yeah, right. Okay, so let's get into a little bit more detail. You got a bunch of things that you want to talk about here, about different considerations that employers should be making when developing their non-competes. And to me, the word enforceable, it's a really important component here, but I also always want to have one foot in the employment brand, the employer brand the side as well. So how do we create non-compete agreements that are in fact enforceable and protect the interests that they're designed, but also strengthen this employer-employee relationship, and just for better communication and expectations on both sides. So
right.
Unpack this for us if you could.
Sure. So Yeah, so I think before I do so, I think there's one caveat I want to explain is that, as we discussed, there are more and more states that are imposing their own limitations, but the things we're going to discuss, the terms we're going to discuss, apply really across the board. There just might be some specifics as to your jurisdiction. But look, what it really comes down to in terms of having an enforceable agreement is that the agreement needs to, the restriction, the non-compete needs to be reasonable in terms of time, geography, and it needs to support a legitimate business interest. So we should break that down. There's a lot there. So, the geographic component, right? So any non-compete agreement is going to say that, the employee cannot work with a competitor, right? That'll be defined for X period of time within a certain location. And so the agreement needs to define what that location is. And what the enforceability depends on how reasonable that restriction is. And so, this is a very legal answer to things, but whether it's reasonable will usually determine on the facts and circumstances of that case and that business and what the employee did.
That was very legal boxing into a corner, Brian.
So, right. With that said, now I'll get into it. But so there are factors that will be looked at, right? So, sometimes you'll have a business that has various arms, and let's just talk about a sales employee. So, and this sales employee, may only deal with one geographic territory, even though the company deals statewide. He or she is only dealing with a certain few counties or maybe one big city in that area. Yeah. So, when we're drafting that geographic scope, we're not just looking at where the business handles things as a whole, but where is this employee working? Where would it be reasonable to restrict them from working? So if that employee is only working in that one city, it wouldn't make sense to restrict them from working for a competitor in, maybe across the state on the other side of the state in a different city, right? What interest would that be serving if that employee had, no knowledge and, no working relationship with customers, in that other area? So I think that's certainly one thing. We want to look at specifically what this employee is doing, not just the business as a whole, in terms of crafting that geographic scope. And then when we look at
Brian, can we stick on geography for a second? So that one makes perfect sense to me. That one seems self-evident, right? Sales rep sells in city X for their territory. They should be able to work for a competitor because they have to feed their family, but in a different city. What about same scenario where it's a sales job, but geography doesn't matter? Maybe you're a software sales rep. Everything you sell is over the internet and Zoom calls. So there's no geography, there's no territory, and you sell your product to the Fortune 1000. So it's a very small, fixed marketplace that you can even address. Could you go to a competitor and be restricted from selling to the Fortune 1000?
Right. Excellent point. And I think with technology these days, right, there's often more and more of a case for nationwide or statewide or even going across the globe, somewhere in Europe, having restrictions that go pretty far. And yes, depending on the business, those national or global geographic restrictions may be reasonable in that circumstance, as long as the company can establish that that type of scope is required to protect their interests, and that it's reasonable in light of other terms. So if you're going to have such a broad geographic scope and that really is required, then we want to make sure that for instance, the time period of the non-compete is narrowly tailored too. And so, right, we want to make sure everything's just to the extent needed to protect the company's, from this unfair competition. So yeah, certainly in some circumstances it'll be broader. I think way back 10, 15, 20 years ago, there was a trend where a non-compete might just list the states, or give a a mile radius, a 50-mile radius from somewhere. I think these days it's much better to define the geographic scope in terms of, I always start with clients and ask them, what counties do we want to prohibit them from working, right? Let's start there. And if we can be, the company can be satisfied that this employee won't compete with them in certain counties, then let's go there, because that's going to be quite reasonable most of the time and narrowly tailored. Maybe it needs to be statewide, or a metropolitan area. But I like to at least start the conversation at the narrowest scale, and then as we expand, have the discussion with the client. Well, what's the reason that we want this to be broader? Because even if and we'll get to this I think in a bit, even if a non-compete is reasonable in geography and time, it needs to also be tailored to protect a company's legitimate business interests. So we're not looking at any of these provisions in a vacuum. They all relate to, really, if a court's looking at this, the real question would be why? Why is this scope necessary to protect the company's interest? And so that should be the overarching thought when defining the geographic scope.
Brian, is there anything you keep saying? Protect reasonable interests. I'm assuming there's some legal specificity for what the word reasonable means, but it probably varies state by state. Should employers who are not attorneys just think about this as the good old-fashioned definition of reasonable, whatever, when crafting these agreements?
So, well, it's a great question, and I think, right, in each state, what's reasonable might be looked at a little differently. In some states there are laws that are on the books, and others the laws developed through court cases. So it's important to understand what may be considered quote unquote reasonable in terms of geography or time in your state. But there are some overarching themes, I think we could say, especially if we're looking at the time period of a non-compete, right? So we're talking about how long that restriction will last from when the employee leaves. So I think, speaking very broadly, if we have a 6-month or less restriction, that typically will be reasonable. If we're 2 years or more, very likely it'll be unreasonable. And so then obviously that leaves the 6 months to 24-month period in between, where again depending on the circumstances, depending on maybe how narrow the restriction is in terms of geography, how important the legitimate business interests are, the level of the employee, those are all things that'll factor into what is actually reasonable. And we've seen some laws. I think for instance in Oregon, they've just limited non-competes to 12 months or less. The law originally said they had to be 18 months or less, and now they've lowered that. So again, it's doing what's necessary to protect the company. And so companies, the question I always get asked is what's the longest period of time we can have this non-compete enforceable for? And my answer, a company, they'll say, well, I want it for 2 years, and I'll tell them, well, we can put that in there I can't, there's no guarantee that that will be enforceable. If you want to be, fairly certain that it's going to be enforceable, then let's narrow that down, make it a shorter period of time. So, it's balancing what will be enforceable with, what the company actually wants.
Right. I might be jumping ahead in the conversation a little bit to enforcement, but these things ultimately, if they're contested, go in front of a judge in court. It's not like a bureaucrat at the Department of Labor comes in and makes a judgment. These are court decisions, right?
That's right. That's right. And yeah.
And so given that, I would think that the more assuming there's ambiguity in the word reasonable, that the more reasonable you are in your agreements, the more favorable a judge would probably look upon you. If you had what were obviously ridiculous, you can't work for another competitor or talk to one of our customers or anybody in this industry for the next 10 years, that you probably make yourself laughable, and therefore even any legitimate claims you might have in this agreement are going to get thrown out, versus somebody who maybe you overstepped the lines a little bit, but if it was clear that you were attempting to be reasonable but perhaps a bit biased, a judge may look on that a lot more favorably. Am I thinking about that right?
Yeah, absolutely. And I think it also goes to the deterrence effect of these, right? I mean, no company wants to get into litigation over, a restrictive covenant. If forced to, many companies will. But the way I look, even though I'm a litigator by trade, the way I look at non-competes is that, I don't want to necessarily be in court to enforce them. I want to have this agreement be something that will serve the deterrent effect and get compliance with it. And so you can expect that if an employee leaves and they're subject to a non-compete, they might speak to a lawyer. They might speak to counsel at their new company to find out what the enforceability would be. So even if you have some draconian restrictions that look great on paper but would never be enforced, that employee will very well find that out. And if they speak to the attorney and say, "Oh, there's no way this will be enforced," then they'll go right ahead, and the agreement may be unenforceable, and you'll be left with nothing, as opposed to the lesser, more narrow non-compete that would have been enforceable and at least gotten the company some protection. And look,
right, so we talked about geography. We talked about keep the groups narrowing it down. Say more about keeping the group small and don't do a one size fits all for the entire employee population.
Right. So as I mentioned earlier, we look at non-competes kind of as a tiered approach to protecting companies. So, at the lowest level of the tier, we're talking about maybe, very low wage earners who are not exposed to a whole lot of, trade secret or valuable confidential information, but you want some protection. So they might just have a non-disclosure. And then you might have, mid-level employees who might actually have more of that confidential information. And, so we might look at, non-solicitation of customers and vendors and employees. And right, when we're talking about non-competes, we're talking about those, that higher level of employees, the ones who, may, have customer relationships, may know all about the company's trade secrets, right? And I say trade, just so we're on the same page, trade secrets are, information, processes, methodologies that an employer keeps secret. And that are not shared outside of the company, and probably not even with all within the company. And they provide a value, the secrecy of those provide a value to the company. And so, employees who actually have those, that might be a reason for a non-compete. And as I mentioned, employees who have relationships with valuable customers. They are, that's the goodwill, right? When we talk about a company's goodwill, those are the relationships, the reputation with customers. And, how is that developed? Is by the, customer-facing employees of the company. And so, again, that just, the first people you think of are sales, but there are many others. But, they are those types of employees, those customer-facing employees are, gaining goodwill for the company. And, those are the types of employees that, when they leave, we don't want them to go to a competitor and then be able to, use that relationship with, your company's, clients and take those away. So, that's why I think, when we talk about non-competes, this is not for everyone. I'm sure, every once in a while there's stories in the news about, large companies that are having, very low wage earners, sign non-competes. And, that's been the target of many of the state laws that have come down in recent years, that non-competes are not allowed for employees earning less than a certain amount, right? For instance, in Illinois, I think that's $75,000 a year. In Oregon, I think it's or in DC rather, I think it's even higher, about a little over 100,000. So, right, the thought should not be, oh, what Mike and Brian talked about today sounds great. I want every one of my employees signing a non-compete. As we'll get to, that there are lesser restrictions that you can have as a whole, but these non-competes are going to be for not just high level. They can be for others, like we discussed in the situation of acquiring goodwill. But there should be specific reasons why you have a non-compete with an employee. There might be unique talents someone brings to the table, right? A unique type of employee, those are fine, right? Then they might be subject to a non-compete. But if you're going to have low wage earners who there really isn't much of a business necessity for them to have a non-compete, no matter how reasonable the agreement is in time and geography, a court is very unlikely to enforce those.
Yeah. I think maybe I'm stealing a little bit from enforcement again, but how about you talk about in writing? How important is it? Let me rephrase the question. It's obviously better to have it in writing. Can you have non-compete agreements that are not in writing, that are oral agreements?
So, what I would say is, depending on the jurisdiction, there's a possibility, but generally no. These things need to be in writing. They are, it's such an important agreement that it should be its own separate agreement. Even one of the muddier areas I've seen is sometimes companies put non-competes or other restrictions in their handbooks, and it's I'm fine with maybe reiterating some of the restrictive covenants in a handbook, just so the employee is aware of them. But you want this to be a written enforceable agreement, right? Just think of going to court and saying, we've got this agreement, and the judge says, where is it? Well, it's verbal. And then you're going to get into the issue of, the company says it was one thing, the employee says it was another. And for such a, the company is asking for, very serious, very restrictive relief from the court, affecting the employee's livelihood, that I think there's very little chance of ever getting, a non-compete enforced where there's no writing. And going back to the handbooks, I think most handbooks, right, have a provision at the end where it says, this is not a contract for employment, and when the employee signs for it, they're just kind of saying, I acknowledge that I've received this handbook and I'll, abide by these policies. But, there's usually that exclusion that this is not an agreement. So trying to put a non-compete or non-solicit in a handbook is typically not a good idea. It should be something that's a standalone document.
So given that it's a standalone document, it is an agreement. One of the things, AKA a contract, in my career negotiating contracts with suppliers and customers, one of the most frequently contested items is the venue. Basically, if I'm in Texas and the vendor is Chicago, Illinois based, they want the venue, the laws of Illinois to apply. We want the laws of Texas to apply because their attorneys live there, our attorneys live here, makes it easier on us, right? And so how should employers be thinking about venue in the presiding law when it comes to these agreements if you have employees that are in different states?
Yeah, so this is actually one of the most important aspects of a non-compete agreement, and is often overlooked, especially right in the circumstance where there are multiple states at play, and that's because as we've mentioned, certain states are starting to view non-competes differently and might have different takes. I can give you an example. In a recent case that I saw, there was an employee who was based in Georgia, and he worked for an Ohio-based insurance company. And so this Georgia employee left the company and went to work for a competitor in Georgia. Now, the restrictive covenant had an Ohio choice of law, even though the employee was based in Georgia, but it was silent as to the forum, right? So it didn't say where any lawsuit regarding the agreement had to be brought. So the employee immediately brought a lawsuit in Georgia state court, seeking a declaration from the court that that the restrictive covenant was unenforceable, that it was invalid, and the employee asked the court to make that decision under Georgia law because that's where he was based, and the public policy would favor enforcing Georgia law. Immediately after that, the Ohio-based company, filed a case against the former employee in Ohio court, seeking to uphold the contract under Ohio law. So you can see, just before they even got to the substantive issues, it was a question of where should this be venued and whose law? And in the end, what happened that the Georgia court, even complicating it more, the company then tried to remove the state court action in Georgia to federal court, thinking that would be more favorable, but it got kicked back to state court. But again, and then in the end, the Georgia state court found that it issued relief, saying that it gutted the restrictive covenant agreement, saying that it would not be enforceable under Georgia law, and that it was going to apply Georgia law because applying Ohio law would have probably validated the agreement, and it would have violated Georgia's public policy. So yeah. So right, long-winded way of saying it's important to consider, where the claims will be brought and the law. And I think, right, that where they will be brought, the forum, right, is not just an issue in terms of, like I was discussing, right, which court is going to decide it necessarily, but also, right, what's most convenient for the company. Right. Oftentimes these when these agreements are entered into, they'll be found reasonable, but you want to make sure that if you're a New York-based company, you're not necessarily making a California employee file something in state court in New York, right? That might be a bit burdensome and maybe unconscionable. So there's some weighing of the factors, and certainly a company might want to seek, legal advice to determine, what the best elements for, choice of law and forum might be.
Right. I mean, it's consistent with conversations you and I have had on the show and others. The trend is there's always going to be big federal laws that we all have to follow, but states increasingly and now increasingly municipalities, counties, and cities have their own laws. And if you are a company with that employs people across a dispersed geography, it's almost impossible to know all those laws, let alone keep up with all those laws as they change. And so there are too many unintended bad consequences by trying to keep things too close. And clearly, the mega trend is towards more employee protection, not employer protection, right?
Yep.
Go ahead.
Yeah, no, certainly, and I think that's what we're seeing in terms of these state, the patchwork of state laws in this area. That it's a common theme again in my discussions with clients when I explain to them what the law, whether it's with respect to non-competes or another area, and the reaction is, well, that's not fair. And look, a lot of the states are looking out for employees, and there's almost an assumption that the employers are the bad guy and will take advantage of these employees. And I think that's somewhat the premise for a lot of these laws, and that regardless of being bad or not, what the issue is a lot of the time with non-competes is the difference in bargaining power between the employer and the employee. Right. It typically comes down to if the employee wants the job, they're going to have to sign the non-compete. That's one of the things that is a reality of the situation. So when you hire an employee, signing the non-compete can be a requirement to start the position. I think one thing we didn't touch on, but I'll touch on briefly, is the consideration element, right? These are contracts, and right, every contract requires consideration, and so a lot of these non-competes are signed at the outset of employment, and courts find that hiring someone, giving them a job, is consideration, is something of value that's given to the employee in exchange for their promise not to compete. But where a lot of companies go wrong, and again, this depends on what the law is in your jurisdiction, is in the middle of someone's employment, they'll ask them to, or probably not ask, but tell them to sign a non-compete agreement. And sometimes the consideration there is just continued employment. Hey, we're not going to fire you. We'll let you keep working here if you sign this non-compete. And in some jurisdictions, that's okay, but in others, they do require something of value to be given, whether it's a raise, a promotion, additional benefits. It could be PTO, could be something of value to that the employee receives in order to agree to these restrictions. And again, that's just a basic tenet of contract law, that an enforceable contract requires obligations from both sides, something of value to be going both ways, and so that's also something to consider if you're a company that's going to have existing employees start signing
So the punchline there, Brian, is that a non-compete agreement should tie back to some trigger event. Obviously, new hire is the perfect time to do it, but also promotion, raise, change of job, use those trigger events, because consideration will be somewhat baked into the transaction. Is that the right way to think about it?
Exactly.
Yeah. Last thing maybe on this before we talk about alternatives to traditional non-compete. And this is what I think you'd refer to as a savings clause. especially in this world of multi-state, geographically dispersed employees, where it's the local venue. So your Ohio, Georgia example was perfect. When you can't know the laws of all these other venues, how do you use savings clauses to retain as much protection of the agreement, even if there are elements that don't abide by the local laws?
Sure. So, right. And this is right. What we're talking about, a savings clause, or sometimes it's called, blue penciling, is where, we put in a provision in the non-compete agreement that permits the judge to edit the restrictions. And essentially, if the judge determines that any of the restrictions are not reasonable or they're overly restrictive, that the judge is permitted to edit the agreement and basically, change it to reflect the employee and the employer's intentions, but within the bounds of the law. So, yeah, obviously, the best practice is to have something that already complies, but these, like you said, it's a savings clause, right? It's just in case it's found, the restrictions are found to be unreasonable, that we can convince the court not to just throw out the entire clause or the entire agreement, but to still give it some force and effect, albeit more maybe more narrowly tailored, so that there's still some protection given. Now, this practice is not without controversy, because again, it's talking about the unequal bargaining positions between employers and employees. One of the arguments against blue penciling is that, look, the company drafted this agreement. They knew what was reasonable or not. The fact they chose something that's unreasonable, it should be thrown out, right? That's the argument against it. And so, look, even in jurisdictions where it's allowed, there are judges who, may not do it, may not, blue pencil an agreement. So, the best idea is to, understand the jurisdiction and what's considered reasonable in the company's jurisdiction. But, as almost a last ditch effort, this type of provision is always good to have in the agreement as a just in case.
So we can come back full circle to good old fashioned definition of reasonable, not technical jargon, but the more reasonable you can be in protecting your interest while not being unreasonable to an employee and their rights to make a living in an industry that they have developed a skill set over X number of years, the better, right? So I'm looking at the clock here. I'm going to move us along. Really good job, I think, unpacking a bunch of the major considerations for putting these agreements together. But let's talk about alternatives to the traditional non-compete, where I'm in this industry and you can't go work for one of my competitors and steal my customers. There are still lots of other really, even if you choose not to do a full non-compete, there's a lot of things that you should be thinking about protecting from an employment perspective, whether it's non-solicitation of customers or employees, right?
Right. So again, I think the very first line of defense is a non-disclosure agreement, and these can be applied to all employees regardless of level, wages. These are very reasonable, using that word, agreements that can protect the company and really don't restrict the employee in any way, other than saying any confidential information or trade secret information you learn about the business during your employment, you will not share for any reason other than working for our business. So
so we might not restrict you from going across the street working for a competitor, but you sure can't share our price list, right?
Exactly. And the good thing about a non-disclosure, it does not need to be limited in time, right? It can be for the entire future, right? You can't disclose this information. So, certainly talking about the tiered approach, minimum wage employees, low-level workers, it's absolutely fine to have them sign these non-disclosure and confidentiality agreements, and that should be a base. And then, moving up from there, right? Then we have, the non-solicitations, and there are different forms of non-solicitation. So for your mid-level employees who may have some, customer relationships, right? You want a non-solicitation of customers that, when they leave, that, we're not saying that they can't go and, work for a competitor. They can, but they're not going to be able to solicit customers. And, again, a non-solicitation should also be reasonable in its scope. So, for instance, we won't, that's again, talk about a sales employee who's working in a certain territory, right? We would often define their non-solicitation restriction by, maybe any company, any client that they've worked with in the past year or 2 years before their termination, that they won't solicit any of those, right? There's, an overbroad non-solicitation would look like something like, you're not to solicit any customer of the company. And that might not be reasonable because that employee may have never worked with some of these companies. And so they would have no information that would really, help them, or, create an unfair competition scenario. And so, it's important to look at exactly what level of restrictions the company needs in terms of that non-solicit. And look at another part, I mentioned, poaching employees before, is a non-solicitation of employees. Those are important too, because look, what often happens is, one employee leaves, then starts talking to others and says, "Oh, I'm working at a great place, you should come." And before you know it, there's a whole department, or a lot of your top talent in one of the company's departments has exited, which is bad enough, and they've gone to a competitor. So you want to have broad enough non-solicitation language that it covers rating employees, and that's not just directly, right? It could be indirectly. Just giving you an example of what I'm talking about, and that I've litigated in other cases, right? Is where we say the employee will not, for a period of 1 year of termination, directly or indirectly, in association with others, hire, solicit, recruit, entice others to come. And what often happens, and what I've seen happen, is the person with the restriction says, "Well, I didn't reach out to them. They reached out to me, and so I didn't do anything wrong." And that's something where you want to make sure the language of the non-solicit is broad enough to cover that, where it's not just that they won't solicit, right? We need more language that, whether it's direct or indirect.
I think this is maybe the single biggest point that I would want to make here for employers is I talked to a small business owner about a year ago, and she said that she didn't want non-competes because culturally, if they don't want to be here, I don't want them here. I want them to go find what the good fit for them, and I only want people who want to be here. And so I understood that, but here we are about a year later, and this same person, speaking to her recently, has had some turnover of staff, and the staff are recruiting her employees. And she had kind of bucketed non-compete and non-solicitation as one thing, and regrets not having non-solicitation agreements in place now.
Yeah, and to be honest, when companies come to me and say, "I want a non-compete," I often start off with explaining to them what a non-solicitation can do. And, we go through whether that would actually satisfy their needs, because, while non-solicitations also need to be reasonable in terms of the time period and their provisions, right? They're much more likely to be enforceable. That most of the laws we're seeing in states are not necessarily applying to non-solicits, mostly of non-competes. So it's something that's much more likely to be enforceable because, right, it's not restricting the former employee's ability, to create a livelihood. So, yeah, it's often something real important that, even in addition to a non-compete or without it, should be put in an agreement.
And tell you what, I mean, somebody goes to a competitor that you don't want them to, and they're competing against you. That might make life harder, but you lose a couple key employees. That can have a much more devastating impact on the business than some trade secrets walking out the door, depending on what the value of those trade secrets, right? So, highly recommend this one. I'm looking at the clock, Brian. I probably let us go too long on considerations. I think you hit the biggies, right? NDA is a no-brainer. Non-solicitation of customers and employees. I think this is low-hanging fruit. Any other alternatives that we should be thinking about?
I think those were really covered, the non-disclosures and non-solicitations. I guess I'll just add that, non-solicitations, right, there are three ways, right? Non-solicitation of customers, employees, and also, vendors. Sometimes there's an important relationship with a vendor, and that, there's some reason to include that in a non-solicit.
Probably a conversation for a different day about how to structure your agreements with vendors, but we'll save that one. And that's probably not employment law, so maybe that's not you. Real quick, let's just touch on enforcement. I think I kept on going there all throughout because everything here we talk about ties back to enforcement. But these are not federal laws. There's no federal non-compete law. There are some states have specific non-compete laws, others don't, and it just historical trends and of case law, I guess you'd call it, right? Where judges base decisions based on decisions of prior cases. I feel like we hit this one. What else would you say in closing about the enforcement of non-compete agreements?
Sure. So I'll just briefly go through the steps that, I'll usually take in enforcing it. And so, well, and even going a step back real quick before I get involved, I think that, when a company has an employee leave who is subject to a non-compete or a non-solicitation, I think it's important to inform that employee of those restrictions. There's often this is often an agreement they signed years ago, and they really honestly might not even remember doing so. They might not be sure if they signed it. If they do remember it, they might not still have a copy. So, I think one recommendation, off the bat is at termination or when an employee, resigns who's subject to such an agreement, give them a copy of it. Remind them of this restriction, not as a threat, just as something that's informative. And then, look, the next step, once if the company learns that the employee has taken employment, accepted employment with a competitor, or otherwise violated some type of restrictive covenant, the first step that we do before going to court would be coming to an attorney and putting out a cease and desist letter. Typically, that will just go to the employee. It'll outline the facts as we know that violate the agreement and demand that they abide by the agreement immediately, and start a conversation and hopefully compel their compliance without going to court. Sometimes, and I just want to put a caveat on it, that sometimes that cease and desist will go to the new employer. There are risks with that because that can lead to some type of interference type claim with their employment. So tread carefully there. But then look, the next step, if the cease and desist and those discussions don't gain compliance, then litigation is the next step. And typically, the most important aspect to a litigation over a non-compete is right at the outset when the complaint is filed. We're going to file a motion for a temporary restraining order, a TRO, and a preliminary injunction. And those are fancy words for saying we want to keep the status quo, or to we're saying for instance example, a temporary restraining order. That's something we're going to file, and we're going to get to court within days, and there's going to be a hearing likely within days, and the court is going to issue an order very quickly, saying until we have the next hearing, this employee cannot work for this competitor, or it's going to contain some element that will hopefully, if obtained by the company, will require compliance with the restrictive covenant pending a more broad hearing. And that TRO, preliminary injunction stage is the most important, because oftentimes the damages in these cases are very hard to prove, and what the company is looking for is not necessarily monetary damages, but just compliance with the agreement. And so that's what an injunction can do. And oftentimes, if the company is able to quickly and swiftly go into court, get a temporary restraining order, or get a preliminary injunction, that's all that's needed. Oftentimes after that, the matter will be resolved. Right, we're not actually going to go on the merits and continue a case and litigate for years and try to get money damages. That does happen. I'm not saying it doesn't, but oftentimes it's just that quick relief that's warranted, and then the sides can come to an agreement about keeping those restrictions in place. So that injunctive relief is really a company's leverage at the outset.
Yeah, very good. Brian, I really appreciate the conversation today. There's a lot to know here. I'm looking at the clock, so I'm gonna rush us through. Sometimes these things can be really complex. Jackson Lewis is a national firm, so regardless of where you are, they're there to help. If you get in trouble, you want help putting these agreements together in the first place. Also, Assure from our outsourced human resource services, whether it's on a small scale just to support your managers, or if you are a solo manager of a company, to provide you the proactive insurance, if you will, of staying compliant with laws, or an entire outsourced solution. Brian and the firm of Jackson Lewis and the Assure team are here to help. So until next week, Brian, I really enjoyed our conversation. I appreciate the value add.
Yep, thanks a lot for having me again.
All right, until next week, thanks everybody.
Thanks.